Praise for
If it can kindly be listed coming Thursday, next Thursday.
next Thursday.
Yes, my lord.
That means next week.
Yes, next week.
It is in the hearing.
Yes, lordship.
So we'll say next week.
Lordship, lordship.
We'll say 1 week. Then it will be fine. Okay. Pray for adjournment of the case. No, Dana Council for the item 15.
Yes, 16. Item 16, lordship.
This is 16. Praise for listing the matter after 1 week, to which the land council for the other side. Your good name? Mr.
Kent.
So has no objection. Stop. In view of the above, list the matter after 1 week. Okay,
Lordship, if the date can be mentioned 9, 11, next week will be 9.
this is for hearing.
On 9, 11, 20, 23, lordship.
Okay. Listing the matter on 9th, huh?
Yes.
Prayer granted. List the matter on 9th for hearing. Okay. List the matter on 9th only, not hearing, huh?
9,
Probably here. This is to be admitted, I think, yet to be admitted, I think.
It has already been.
LCR received, or already admitted.
Yes, lordship.
Okay, then in that case for hearing. Okay,
Oblige you.
Obliged, my lord. Lordship, I have a similar prayer for item 21. If you can kindly come up after 2 weeks. I am for the appellant here as well.
okay. Land Council for appellant, Mr. Satyanga. Praise for adjournment of the case for 2 weeks. Do you have any objection?
No.
Okay, Land Council for Land Government Advocate, Mr. So-and-so has no objection to the prayer made by the Land Council for the petitioner. Prayer granted. List the matter after 2 weeks.
Deeply obliged.
Okay.
May I please, your lordship? I beg to mention item number 6
Yes.
on behalf of my senior Azimoni.
6.
Yes. Kindly grant us 3 weeks' time to file our affidavit.
You're for the
Respondent.
respondent, who is for the petitioner?
Lordship, I'm appearing on behalf of the petitioner, Lordship.
You are for the petitioner.
Yes, Lordship.
You have any objection?
No, Lordship.
Okay. Land Council for the respondent, Miss
And solo,
Sumo, pray for
3 weeks' time.
praise for 3 weeks' time. This is for admission. Okay. 3 weeks' times to which the Land Council for the petitioner has no objection. Stop. Prayer granted. List the matter after 3 weeks.
Lordship, there is an interim, Lordship.
In the meantime, the interim order granted earlier shall continue. Okay.
Oblige, my lord. May I please, Lordship? Lordship, I beg to mention item number 17 and 18, Lordship, on behalf of the counsel for the appellant. So, Tayong Chuba, Lordship.
17 and 18.
Yes, Lordship. Lordship, I pray that this matter may come up again after 2 weeks, Lordship, since he has some personal difficulties, Lordship.
You are for
The appellant, Lordship.
appellant, who is for
Lordship, I'm for respondent number 23.
no objection.
Okay.
Okay. Land Council for the appellant, Mr.
Envero, Lordship, on behalf of Sir Tayong Chuba.
Okay, Land Advocate, Mr.
Envero, on
Uh,
behalf of Tayong Chuba.
Ampero, appearing on behalf of the Mr.
Tayong Chuba.
Tang Chuba, Land Council for the appellant, praise for
2 weeks' time, Lordship.
2 weeks' time. To which the Land Council for the respondent, Miss, has no objection. Start. Prayer granted. List the matter after
2 weeks.
2 weeks. Okay.
Lordship, I have similar prayer for item number 27, Lordship.
27.
Yes, Lordship, on behalf of the counsel for the appellant, Fosoko Forte, Lordship. After 2 weeks, Lordship,
Here you are for
for the appellant, Lordship.
appellant
Yes.
Forte. Land Advocate, Mr. So-and-so appearing on behalf of Mr.
Fosoko Forte,
Foseko Forte. Praise for
2 weeks' time, Lordship.
2 weeks' time, to which the Land Council for
5 and 6.
The respondent 5 and 6, Miss so and so, has no objection. Who is for the other respondent? Have you
We have taken
informed?
the consent, Your Lordship.
Okay,
Yes,
prayer granted. List a matter after 2 weeks.
much obliged, Your Lordship.
May I please, Your Lordship?
Yes.
Lordship, I beg to mention item number 11, Lordship. I'm for
11.
respondent number 1 to 4, Lordship.
Okay,
So,
you are for
Lordship,
respondent number 1. Who is for the petitioner? So you have any objection? No, okay. Learned counsel for, learned advocate, Mr. So and so. His name, huh? Appearing on behalf,
respondent
for
1
the
to 4.
respondent number 1, 1 to
1 to 4,
1 to 4
Lordship.
is a, okay, praise for, you have filed the affidavit?
No,
For-
Lordship.
Okay,
3 weeks
praise
time
for 3 weeks time to file affidavit.
to get the necessary instruction.
Okay, to get the instruction?
Lordship.
Okay. 3 weeks time to obtain instruction from his client, to which the land counsel for the petitioner has no objection. Stop. Prayer granted. List a matter after 3 weeks.
Lordship.
Okay,
I love it.
May I please, Your Lordship?
yes,
Your Lordship, I beg to mention item number 29, Your Lordship, for hearing, Your Lordship.
29.
Yes, Your Lordship. Your Lordship, I pray that the matter be listed on 13, Your Lordship, 11/2023, Your Lordship. Consent have been taken from the opposite party,
Okay, you are for,
the petition, appellant, Your Lordship.
your name is there. Okay,
Absolutely,
land advocate, Mr.
absolutely,
M.
so,
Sonda. M. Sonda. For the land counsel for the appellant, praise for adjournment of the case for,
13, Your Lordship. Fixing on 13.
oh, for fixing,
Yes, Your Lordship.
30,
13, Your Lordship, 13.
1, 3. Pray for fixing the matter on 13 for hearing. He has a consent form.
Consent have been taken, Your Lordship.
He is obtained a consent from the respondent. Prayer granted. Fix the matter on 13 for hearing. Okay,
Your Lordship, I also beg to mention item number 7, Your Lordship.
let the matter be listed on 13 for hearing, huh? Okay, yes,
Item 7, Your Lordship.
7.
Yes, Your Lordship. Lordship, here I'm preparing for the petitioner, Your Lordship. Lordship, we have received a copy of the affidavit filed by the private response, Your Lordship. If that-
13 is with IA,
7, Your
12.
Lordship, 7.
Oh,
1,
7.
Yes, sir. Criminal petition.
Okay,
Lordship, if time be given to file our reply to the affidavit filed by the private response, Your Lordship.
who is appearing on behalf of the respondent?
Chief state is for respondent number 1. State has not much to say.
Oh,
Lordship, the counsel is on his legs in court, feet in court 1, Your Lordship.
okay. So have you,
3 weeks time given, Your Lordship.
have
file
you
a-
taken consent from him?
Yes, Your Lordship.
Okay, land counsel for the petitioner. Prays for
3 weeks time.
3 weeks times to file,
Reply to the affidavit
okay,
filed by the
reply to the affidavit filed by the respondent,
private respondents, Your-
5,
private respondents.
filed by the private respondent.
Yes, Your Lordship.
Stop, huh? Land counsel for the respondent number 1, Mr. Mr. The respondent number 1 is government,
Worship for state, worship.
For state.
or state, okay. Land government advocate, Mr. So-and-so appear on behalf of the respondent number 1. And he has no objection. Stop, prayer granted, list a matter after 3 weeks.
Your Lordship, there's an interim, Your Lordship.
Yes,
Interim, Your Lordship, there's an interim.
okay.
Let
In the meantime, the interim order passed earlier shall continue.
Lordship.
Okay,
May it please your lordship, I
Yes.
beg to mention hearing item number 22. If your lordship may kindly refix this matter after 2 weeks' time, since the government advocate who is on this matter is on leave. Who is representing this case is on leave.
you are for
The petitioner.
petitioner. The government advocate is on leave,
Yes, your
the
lordship.
respondent.
Yes,
okay.
your lordship.
You are praying for adjournment on what ground?
Since the Government advocate who is representing
Okay.
this matter is on leave
Okay.
for that, Your Lordship.
Mr. Your name, good name?
KV Kure on behalf of Joshua Shiki.
Okay. Appearing on behalf of Joshua Suki, land counsel for the petitioner. Praise for how much? How much
Next
time?
Your Lordship.
2 weeks time. Stop. None appears on behalf of the respondent. The prayer is granted. List the matter after
2 weeks time.
2 weeks. Okay.
Bless you.
May it please your lordship.
Yes.
Lordship, I beg to mention for item 12 and 13. Lordship, the leading.
Item
cause-
13,
12 and 13.
12 and 13.
Yes, lordship.
Yes.
Lordship, the leading counsel for the petitioner, Mr. Ilivel Zhao, is out of station. So let this matter come after 2 weeks.
Okay. Learned advocate, Miss,
Asna Longkama,
appearing on behalf of Mr.
Ilivel Zhao.
Oliver Zhao, learned counsel for the petitioner. Praise for how much time?
2 weeks time,
2
lordship.
weeks time. And who is for the other side? Okay.
They are yet to enter appearance.
Okay. Not yet.
Not yet, lordship.
Okay. As the leading counsel is out of station on leave, huh? Leading counsel is out of station. Stop. Prayer granted. List the matter after 2 weeks.
Much obliged, lordship.
Okay.
Please, Lordship.
Yes.
Lordship, I beg to mention item number 4. Lordship.
4.
Yes, Lordship. Lordship, I'm here to file my affidavit in opposition, Lordship. So kindly grant me 2 weeks time.
You are for the respondent,
Yes, Lordship, for the sole respondent.
sole respondent, and you?
After the revisions.
Okay. Both the land counsel for the revision petitioner and the sole respondent, revision petitioner, Mr. So-and-so, Mr.
I, Jamir.
Johnson, and Mr.
Nsugaji, Lordship.
for the sole respondent are present, staff. The land counsel for the respondent prays for how much time?
2 weeks time, Lordship.
2 weeks time to file affidavit to which the land counsel for the petitioner has no objection. Stop. Prayer granted. List the matter after 2 weeks. Okay.
Much obliged.
Yes.
May I please, my lord?
Yes, please.
Lordship, I beg to mention item number 10.
Then,
Lordship, here in this matter, I'm appearing for the performer respondent 3, 4, 5, and 6. However, since the matter is in the order column, Lordship, whether they are also respondent number 1 and 2.
Lordship, we have instruction to appear on behalf of respondent number 1, Lordship.
what you are for 1 and 2?
For 1, Lordship, respondent number 1.
1
Yes, Lordship. 1.
and for 2?
Do know, Your Lordship. State is performer respondent 3, 4, 5, and 6.
Okay.
2 is
Private.
private respondent. It's a village council. If I'm not wrong, Your Lordship.
Okay. So you are seeking time for?
Lordship, in this matter, actually the main party respondent is the respondent number 1. The state have got nothing much to say here, in fact, Your Lordship.
Okay. So what is this matter about?
It's a land issue.
Okay, so you are for the petitioner.
Petitioners.
However, Your Lordship, if it is in the order column, maybe the notice upon the respondent number 2 may not have been completed, Your Lordship.
Okay. Respondent number 2, no?
Lordship.
Okay, hard line counsel for the petitioner, Miss So-and-so. And also, Mr. For the respondent number 1 is?
Yes, Lordship. And Vero, Lordship.
0 for the respondent number 1 and Mr.
And Angami, Your Lordship,
and Angami.
for performer respondent 3, 4, 5, and 6.
You are government advocate,
Senior government.
senior government advocate for the respondent number 3, 4, 5, and 6. Stop. As none appears on behalf of the respondent number 2. None appears. No one appears. Have you
Lordship,
Taking
I
steps.
serve, copies.
copy served?
Just to respond to, yes.
Whether it is returned? None appears on behalf of the respondent number 2, stop. As prayed for by the land council for the parties. List the matter after 2 weeks,
3 weeks? Your
3
Lordship.
weeks, 3 weeks. Okay.
Obliged.
For motion, item numbers 1 and 2.
Which one? Okay, not this one. Third. Okay. Oh, yes.
May I please, minutes?
Yes, please.
So minutes this is minutes all connected matters, item 1, 2, and 3. So minutes in item 1 and 2 minutes, if my lords may kindly see the order passed by this honorable court in item 10, that is 17/10/2023.
What a pass in item?
Item 2 minutes.
Okay.
Item 1 is amendment application, minutes. For that, the leave was granted by this honorable court by the order dated 17th October 2023.
In item 1?
In item 2, minutes.
Item 2.
Yes, minutes.
Order dated 17?
Yes, my lords, 17th October. My lord
Yes.
has it. So, my lords,
Yes.
I will read, my lords. This
Yes.
application under section 482 of so and so, praying for quashing of complaint case bearing number so and so, which is pending before the learned CGM Pere Nagaland. Learned counsel for the petitioner has submitted that the learned CGM Pere Nagaland has taken cognizance of the offense under section 138 NI Act without considering the fact that it was apparent from the materials which was placed before the learned CGM that the notice under proviso B and C of NI Act 1881 in the complaint case has not been served on the present petitioner as the same has been stated in the complaint petition. Therefore, learned counsel for the petitioner submit that ingredients of offense of section 138 of NI Act 1881 is not present in the instant case, as the same is only said to have been committed after lapse of 15 days period of the date of receipt of notice issued to the person who issued to the check which was dishonored. However, in the instant case, the pleadings made in complaint case itself shows that the notices under section 138 proviso B and C NI Act was not served on the present petitioners. Counsel for the petitioner has further submitted that due to inadvertence, some defective documents have been annexed to the instant criminal petition, which are required to be rectified, and seek leave of this court and submit that he would be filing an application for amendment of the petition under section 482 of the CRPC. The petitioner is allowed to file necessary amendment petition seeking amendments in criminal petition as desired. So in this background, my lords, the item 1 is there before my lords today on board, the amendment application. So what has happened, my lords, that the documents which were filed that was given handed over. So we have then obtained the documents from the concerned parent court, and it was handed over across the bar by my learned colleague over there, Miss Lucino, to the honorable court. And then it was observed by the honorable court that these documents must come on record along with an affidavit. So that's why the item 1, the application is there. Now, if my lords may kindly see, in item 1, my lords, the amended writ petition is annexed. So I will just show only 2 things, my lords. I have read the order for my lords' perusal. This is a matter where, my lords, the petitioner, the complainant, the respondent herein, the complainant before the parent learned CGM court, is himself stating on affidavit that he is a resident of Delhi. Now, my lords, this is a case where the complainant and the accused persons are native of Delhi, my lords, undisputed. I will show from the address. So there was some business transaction by and between complainant and the petitioners here in the accused person. Now, my lords, the business relations turned sour on account of various reasons, my lords. Now, what happened, my lords, in the meanwhile, I was apprehensive that certain checks belonging to partnership concerned, that is petitioner number 1 before my lords, were stolen by the complainant. way back on 2022 August, my lords, I have filed a complaint before the concerned police station with regards to the check being stolen, and I have also served the notice, and that notice is also being responded, my lords. Now, what happens, my lords, that the
Were the case registered?
in Peren, my lords. No, that is only the complaint pending, my lords.
Complaint or FIR?
No, it is a complaint, my lords, not FIR, as of yet.
Complaint before?
Complaint before the police station. And the notices have been also issued, my lords, way back in 2022. I will just show to them, my lords.
Okay.
What happens, my lord? The interesting part is, my lord, that despite thereof, my lords, the complainant proceeds to present one of the 4 checks before New Delhi Yes Bank, Rohini branch. There is a place called as Rohini in New Delhi. So the check is presented, my lords. Since a stop check instructions was given to the bankers, the check got dishonored, my lords, on account of a stop back instruction. The complainant, my lords, issues a notice under section 138 of NI Act on account of the first check which was dishonored upon its presentation before Delhi Bank. That notice is there.
Check which was stolen.
Yes, my lords. 4 checks. So for the first check, despite of my complaint to police and despite of my advance notice to the complainant, the first check was presented at New Delhi Yes Bank. I will show from the records. I respond to that notice, my lords. Upon receiving that reply, the complainant opt not to initiate 138 proceedings in lieu of the notice which he has served upon me before the concerned territorial court. That would be in Delhi, my lords. Then what happened, my lords? He goes silent. Then he altogether travels to Nagaland, my lords. He opens a bank account at Dimapur, Peren, my lords. He presents the check, and my lords, he get it bounced. He do not even serve a legal notice. I will show from his own admission, and then he proceeds for filing of the complaint. The learned CGM court, my lords, in my respectful submission, without applying the judicial mind to seeing that whether the proviso B and C to appended to 138 are being satisfied or not, mechanically issue summons, my lords. And even the bailable warrants were issued. On the last date, my lords, when I prayed this, I have brought this to the kind attention of this honorable court. My lords was pleased to protect me and to say that you go and file an application for exemption from personal appearance, and that would be allowed, my lords, and that was allowed. Now, my lords, in this background, I will pray, my lords, to see certain admitted parts from the petition itself. If my lords may kindly see, the impugned order is at page 59 of the amended petition, item 1, pillars.
Item 1.
Yes, my lords, page 59.
Item 1 is only 59 is not there.
Item 2, Lordship, criminal petition
So
of
the item
26th
2?
of 2023.
Item 2, I
Yes,
suppose.
my lords. Amended rate petition may kindly be seen, my lords.
Amended writ petition of 26.
Yes,
Criminal petition 26.
yes, my lords.
Amended. Page.
Page 59.
Okay, true copy.
Yes, my lords. True type copy of the impugned order. Now, my lords may only see. I will just read the last para, my lords. The complainant produced K. Samuel Medallion as a witness of the case and due inquiry was made under section 202
So
subsection.
where are you reading?
My lords, page 59, the last para.
Okay.
The complainant produced K. Samuel Medallion as a witness. My lord, has it?
Yes.
Of the case and due inquiry was made under section 202 subsection 1 of CRPC. After recording his deposition, there are sufficient prima facie materials to proceed against the accused, Mr. Spark Project Major Vikas Chillar retired, and Sonam Singh under section 138 of NI. Therefore, summons upon the accused person. Now, my lords, may kindly see the next page. That is the copy of the complaint, page 60.
Yes.
Now, my lords, may kindly come to page 68, para 17 of the complaint.
Yes.
Thus, the complaint through its counsel issued a statutory legal notice dated 2nd March 2023, which was sent on 3rd March 2023 by speed post, thereby calling upon the accused person to pay the aforesaid check amount within 15 days from the issuance of aforesaid notice. However, despite mentioning the last known address of the accused person in the above said legal notice, the same was returned on account of address being inaccurate. It is pertinent to mention that even after the best endeavor of the complainant, the current address of accused person could not be traced. Therefore, the complainant is constrained to prefer the present complaint before this honorable court. Now, my lords, the admitted part that the notice was not served. Now, I will show, my lords, insofar as the complainant assertion that the last known address vis-a-vis, I will show just one document which will show, my lords, that they have all my address. If my lords may kindly see page 102.
Yes.
My lords, this is a notice being issued, reply to a notice being issued by the complainant through his counsel. Now, my lords, may kindly see the first page. It will show under instructions of Balaji Enterprises proprietor acting through representative proprietor Kumar Rajesh. He is the complainant. Now, my lords, may kindly see the top of it, the address. The addresses are there, my lords. And my lords, the interesting part, please see, my lords, the address number 2. They have my email address. They have my mobile number. Even if the address was not served, my lords, in this electronic era, my lords, the email addresses and WhatsApp numbers would suffice, my lords, but the notices were deliberately not sent, my lords. The notices were deliberately concealed, suppressed. Now, my lords, in this background, if my lords may only see the tracking report which he has annexed, exhibited, that is at page 93. It's a true type copy, my lords. So, my lords, may kindly first see page 94. So,
yes.
My lords, the last, on the bottom of the page, my lords will see event item booked office new Nepali Gaon SO.
Last.
Yes, my lords. In 94, the last. Now, my lords, after this, in the 94 top of the page, my lords, may kindly see 1, 2, 3, 4, 5, 6, 7, 8. 8th item, my lords. Event.
8 from top.
See, yeah, from the top of 94, 8th item.
Okay.
My lords would see item returned insufficient address. Now, my lords, in this background, my lords, will see page 93. Now, my lords, the consignment, that is speed post consignment, is being returned by Circular Road SO, my lords, in Dimapur. Now, my lords, the notices are not served.
Where do we find consignment return?
Yes, my lords, may kindly see page 93. From these item date times 1, 2, 3, 4. Event item delivery confirmed, office Circular Road SO.
Okay.
So, my lords, what happens that the item is booked from Nepali Gaon, my lords. Then it travels all together, my lords, as per the India Post, this India Post Department, my lords. When the item was not delivered, then it comes back to the original sender. So it has come to Circular Road SO, and then it would have been returned, my lords, to the complainant or the counsel.
This is the record of return.
Yes, my lords.
Okay.
Now, my lords, in this premise, my lords would kindly see section 138, my lords. I intend to buttress my submission in so far as, my lords, a statute is concerned, that why the offense under section 138 will not be deemed to have commenced if the notice is not being served, my lords. So if my lords would see section 138,
138.
in Negotiable Instrument Act, my lords.
Negotiable. And negotiable instrument.
May I read, my lords, for a moment?
Yes, just a minute.
Yes, my lords.
Section 138.
Yes, my lords. My lords, the 138 deals for the dishonor of check for insufficiency, etc. funds in the account. And my lords may kindly come to proviso, my lords. Provided that nothing contained in this section shall apply unless
Yes, unless.
yes, my lords, unless A is, my lords, the check has been presented to the bank within the period of 6 months from the date on which it is drawn or within the period of the its validity, whichever is earlier. B, the payee or the holder in due course of the check, as the case may be, makes a demand for the payment of said amount of money by giving a notice in writing to the drawer of the check within 30 days of the receipt of information by him from the bank regarding the return of the check as unpaid, and the drawer of the check fails to make the payment of the said amount of money to the payee or, as the case may be, to the holder in due course of check within 15 days of receipt of the said notice. Now, my lords, the law is quite settled, my lords, that one merely bounce and return of check is ipso facto would not be deemed to be the commission of offense under section 138, my lords. The what law stipulates in my respectful submission, my lords, that the check has to be presented. If the check is dishonored, my lords, upon receipt of the returning memo or information from the concerned bank, my lords, within 30 days, a legal notice, a statutory legal notice under section 138 has to be sent. And, my lords, even upon receipt of the legal notice, the offense is not committed. The offense would only be deemed to be committed if the drawer of the check, despite of receipt of legal notice, in 15 days has failed to make the payment. So in this case, if my lords would connect the dots, I have shown to my lords that with regards to first check, which was presented in Delhi, my lords, I will show the notice. My lords may kindly see page 133. Page 120, my lords, is the police complaint. I will not burden my lords with that police complaint. I will just show my lords page 133. This is a complaint being filed by me, my lords. It is page 133, my lords. I'm so sorry. Page 133, it is a legal notice which was issued to me in lieu of the first check which was dishonored. My lords would see page 133, date is 21/2023.
Notice issued by?
The complainant for the first check which was presented in New Delhi. I will just read, my lords. The addresses, now my lords will see.
First check was for how much?
My lords, 50 lakh rupees, my lords.
50 lakhs.
Now, my lords will kindly see the first page. Again, my lords, in column 2, Major Vikas Chiller, retired. My lords would see email and mobile number again of my email and my mobile number.
2.
Yes, my lords. So, my lords, three mobile number is also mentioned. Mrs. Sonam Singh, though she is wife of Major Vikas Chiller, my lords. So her number is also there. But interestingly, my lords, this email address and mobile numbers are there, and I have received this legal notice. I have responded to this. Now, my lords, may kindly see in this legal notice. My lords, may kindly see page 137, para 10 of this legal notice.
Yes.
On 29/12/2022, our client, believing that the above mentioned check would be honored on its presentation for encashment, presented check number 291330 dated 29/12/2022 for rupees 50 lakh through its banker, that is Yes Bank Limited, 387 Rohini 2. I take a pause, my lords. This Rohini 2 is New Delhi, my lords.
Just a minute. This is
This is the first check which he has presented in New Delhi, my lords.
okay.
It
This
was
is
announced.
the notice. This is a notice.
Yes, my lords. This is the statutory 138 notice duly received by me.
Okay.
I want to show, my lords, that first check was presented in New Delhi. And the complainant had all address of mine, my email address, my wife email address, my mobile number, everything was in complaint position. Now, my lords, this notice was replied by me. My lords, may turn to page 140.
Yes.
Page 140, my lords. This is a reply. My lords, may kindly see the subject. Reply to legal notice dated 21/2023, my lords. Now, my lords, in this notice, if my lords may only see para 16, that is at page 145.
Yes.
At this juncture, our client has stated that issuing of notice under reply ex facie establishes the fact that your client, with his nefarious designs and ulterior motives, have forged and fabricated the said blank, albeit signed check, and have further presented the said check for causing wrongful gain to himself and wrongful loss to our client. Now, my lords, this notice was para 17, my lords. I will also read. It is pertinent to mention herein that our client, while issuing the legal notice dated 26/8/2022 and rejoinder dated 3/9/2022, had cautioned your client to return the stolen checks, and failure to do so, our client shall be constrained to initiate appropriate legal proceedings in this respect as well, without prejudice to its right and contentions. Now, my lords, this notice was served, my lords. After receiving the legal reply to the legal notice, my lords, the complainant did not, my lords, and I emphasize, my lords, the complainant did not file its complaint before the concerned jurisdictional court, that would be in Delhi, my lords, in Rohini. Now, what he did, my lords, that he thought that he will not be able to intimidate and harass me in New Delhi, my lords. Petitioner number 3, my lords, Sonam Singh, is the mother of 2 minor child, my lords, of 4 years and 2 years. So he altogether traveled to Nagaland, my lords. He somehow got a bank account opened there in Dimapur, Perin, my lords. He presented one of the check, got the summons issued by the honorable court below, my lords, just in order to me to harass and intimidate. But be that as it may, my lords, I am purely on the question of law, my lords, in which this honorable court will appreciate in my respectful submission, that when it is an admitted position of the complainant in complaint itself filed before the learned CGM court, my lords, that the legal notice was not served upon the accused person, which are petitioners before my lords today. My lords, I ask a question to myself, my lords, how, my lords, section 138 offense would be deemed to be committed, my lords. So in this context, my lord, my respectful submission is this, my lords, that learned court below, trial court below, has grossly erred, my lords, in overlooking, my lords, in ignoring the settled legal proposition from the statute 138 B and C itself, my lords. And therefore, the petition deserves to be allowed, my lords, and the summoning order needs to be quashed, my lords, in my respectful submission.
Notice was issued?
No, my lords, the problem was, my lords, because these documents was due to, my lords, the logistic issues, I was not able to produce these documents which are before my lords today. So these were handed over to the honorable court on last date. So the honorable court was of view that I must, and that was, my lords, the correct proposition, I must bring these on record by way of affidavit. So, my lords, from the last date, if my lords will see the 17th order, notice was not issued, but my lords was pleased to protect me from coercive action. If my lords may kindly see 17th order,
Yes.
the last page, my lords, as page I will read just two last paragraph of the 17th order. It is also submitted that as in the said case pending before learned CGM Peren Nagaland is fixed tomorrow, that is on 18/10, where bailable warrants have also been issued against the present petitioners. Hence, it is prayed that some time may be granted to the petitioner to appear in the said court so and so, and they may be allowed to appear through counsel. Considering the submission made by the learned counsel for the petitioner, as well as considering the fact and circumstances of this case, and considering the fact that already the prayer for filing and petition for amendment of the instant criminal petition has been allowed, the petitioners are hereby allowed to appear tomorrow so and so through before the court of learned CGM in complaint case number so and so through their appointed counsel, and the learned trial court shall allow the prayer for dispensing the personal appearance until next date fixed, if such a prayer is being made by the learned counsel for the petitioner, and let the matter so and so. Now, my lords, my only respectful prayer today before this honorable court is this: my lords, may kindly stay the proceeding on account of the grave omission, my lords, and on account of the fraud, misuse of the process of law by the complainant, my lords. I have shown to my lords all the documents, admitted documents. These documents are the certified copies. Copies of the certified copies is applied from the Peren courts, my lords. And therefore, my lords, I respectfully pray that while issuing the notice, this honorable court may stay the proceeding, or this honorable court may protect me, my lords, from traveling to Nagaland, because I am facing my threat, my lords, there. The scheme being designed by the complainant is somehow I come to Nagaland and they get hold of me, my lords. That's all the scheme, my lords. There is more what meets the eye, my lords, in my respectful submission.
This is amendment petition. Okay. Item 1 is IA submitting this is only
Amendment application, my lords.
amendment application.
My lords.
Notice need to be given here in this amendment application.
My lords, along with the petition, my lords, it may kindly be issued, my lords.
Okay.
Because this was on the document part, my lords, and 17th order, my lords, categorically allows me to file that, my lords.
Yeah. Learned counsel. Dr. Farooq.
Yes, my lords. Grateful.
Farooq Khan, learned counsel for the petitioners. On being allowed, on being allowed by an order dated 17/10/2023. For filing amendment petition. The petitioner has filed this amendment petition. Staff, issue notice upon the respondent, returnable by 3 weeks. Returnable by 3 weeks.
Grateful, my lords.
3 weeks or where this is the place? CJM court?
Perin, my lords, Perin.
Perin is far away.
Perin. Nagaland, my lords, in Perin.
Okay, 4 weeks, we'll say 4 weeks, okay. The petitioner shall take steps upon. How many respondent?
This
One.
Yes, my lords.
All respondent.
So take steps upon the respondent. Within how many days? 3 days,
Within a week, Your Lordship.
within a week from today. By a registered post with AD.
Lordship.
Stop. Huh? Considering having regards to and having regards to the submission the contention made in the petition and also hearing the Land Council for the petitioner. The stay will have hearing on the stay on a question of stay on the next date.
So, my lords, in the meanwhile, my lords, the next date before parent court, no, my lords, my instructions are very near, my lords. I think on 10th or 9th of November, my lords. So they will issue non-bailable warrant, my lords. So, my lords needs to protect me, my lords. 9th of November is the matter before the parent court, my lords, the learned CGM court.
9th.
Yes, my lords. So if my lords are considering for passing an order on a stay after hearing, my lords, after notice, so in that submission, my respectful submission would be, my lords, may dispense my personal appearance of the petitioners before the learned CGM court and allow the petitioners to appear through the council, my lords.
Where what is your interim prayer? Have you made interim prayer?
Yes, my lords. My interim prayer at page 53. Page 53, my lords, the interim prayer is, if my lords would see, pending disposal of present petition, your lordship may be pleased to stay suspend further proceeding in connection with criminal proceeding arising out of case number so and so before the learned CGM court.
The interim prayer shall be considered on the next date, returnable date. Stop. However, considering the contention made in the petition and also the submission made by the Land Council for the petitioner, the personal appearance of the accused.
Accused persons, my lords. Yeah.
Accused persons.
2 persons, my lords. Petitioner 1 and 2, my lords. 3. Petitioner 2 and 3, my lords. 1 is the partnership concerned, my lords.
Okay.
My lords would say petitioners, my lords, because anyway.
The petitioners.
Yes.
In that case, accused.
Yes, my lords, accused.
The accused shall be allowed to be represented by their counsels.
My lords.
Till returnable date.
My lords.
So, put up this matter after 4 weeks. Okay.
I'm so grateful, my lords. In item 3, my lords, it is the same matter, just a check number is different. So it's a fresh petition.
Same matter.
Same matter, my lords, the check is different.
Check is different.
Yes.
Registered in the same court. Okay, similar order.
Yes, my lords, similar order, my lords.
Lordship, if the IA can be disposed of.
Okay. No, since notice has been issued in both notice,
Lordship, this IA is just praying for the leave of this court to amend the petition, Your Lordship. So, Lordship, if
Okay.
I
Okay.
think issuing notice in this will not be necessary, Lordship,
Okay,
since it's just for amendment.
Amended was already allowed.
Yes, Lord.
Yes, my lords.
Okay.
At 17th, then the honorable court is allowed, my lords.
Hmm. In view of the above, then in view of the above, the IA stands disposal. IA stands allowed and allowed already. IA stands disposal. Okay.
Like,
I'm grateful. So my lords will also consider passing the interim order in item 3, my lords.
Similar order.
I'm so grateful, my lords.
It
Deeply
is.
grateful. Obliged, my lords. Deeply grateful. Deeply grateful.
Yes.
May I please, Lordship?
Yes.
My apologies, but I couldn't mention an interim in item number 10, if I may be allowed to mention. I mentioned the matter earlier.
Item.
Item 10.
What do you want here?
I want to mention the interim.
I think someone mentioned.
Interim. Yes,
First.
I mentioned the matter, but I couldn't
Mention.
mention
Item
the
10
interim.
mentioned. Already mentioned.
The interim order.
Oh, interim.
Yes, Lordship.
In the meantime, the interim order passed earlier shall continue.
That's
Okay.
okay.
From the supplementary cost list for motion, item number 28.
Okay. Yes, this is a suo motu petition.
Yes, Lord.
Yes. So learned PP will assist. Okay. So here in this case, it appears that the government of Nagaland has transferred the case from Mokokchung to Dimapur. And it was communicated to the principal district and session judge Mokokchung, Nagaland, where the case was pending. And on receipt of the community order dated 13 October 2023, the principal district and session judge Mokokchung referred the matter to the registered Gauhati High Court, stating that the government has transferred the case, whereas as per the 406 CRPC, the High Court has the sole power to transfer the case from one court to another. And the same was forwarded to the principal seat for this year for further direction. And then the principal seat has made a request to the registered Gauhati High Court Kohima bench for registration of the suo motu case for transferring, and hence this is the case registered. So for the time being, we'll issue notice to all the parties, including the accused persons, informant. Okay. This is a suo motu transfer petition filed by the register of the Gauhati High Court, Kohima bench. Stop. Para. The matter has arisen out of the reference made by the principal district and sessions judge Mokokchung, Nagaland, addressed to the Register, Gauhati High Court, Kohima Bench, Nagaland, by his letter number PDNSJ stroke MKG stroke ESTT -1 stroke 2023 -24 stroke 94 dated 17/10/2023, informing that the government of Nagaland, Department of Law and Justice, Kohima, by an order dated 13 October 2023, has transferred the GR case number 34/23 arising out of Mokokchung MKG PS 2, case number 13/23 under section 120B 34/365/32 IPC from Mokokchung to Dimapur, and stated that wherein he has also stated that under section 407 of the Criminal Procedure Code, the power of transfer of case vests on the High Court, vests only with the High Court. Yes. Hence requested to bring the same into the notice of the Honorable High Court for necessary direction. Stop. The Register, Gauhati High Court, Kohima Bench, Nagaland, had then forwarded the said letter to the principal seat at Gauhati, principal seat of the Gauhati High Court at Assam, while his letter number HC within bracket K bracket close 10/2009/REG/530 dated 17 October 2023 on the same date, for decision on the administration side. Stop. Para. Issue notice to all concerned, including the informant, victim, and all the accused persons stop. The notice is made returnable by 4 weeks, within 4 weeks. Okay.
My lord, along with all the relevant documents.
Okay. There's hardly documents, 3 documents. Yeah, okay, stop.
The documents.
The Learned Public Prosecutor, you accept
the
on notice?
same.
Okay. Learned Public Prosecutor, Learned Public Prosecutor Nagaland, Miss so-and-so accepted notice on behalf of the state. However, the documents
Documents has to be finished.
documents shall be furnished to her during the course within 3 days. Stop. The registry shall cause notice upon all the accused persons all the parties, including the informant, victim, through registered post with AD, and to the accused persons in jail through the SP jail or the jail superintendent. SP jail stroke jail superintendent. Stop, huh? In the meantime, pending disposal of this application, the trial proceeding of the GR case number
34.
Yes, GR case number 34, 2023, 23, arising out of MKGPS 2, case C stroke number 13 to 23 stroke 23 under section 120B 34 365 302 IPC. In the pending before the principal district and session judge Mokokchung, Nagaland cell remain state. Stop. List is made after 4 weeks. And in a notice earlier, when I say not a notice issues to the all parties, along with the relevant documents, just add one relevant documents. Okay. God bless you.
For admission, item number 5.
Please, Your Lordship.
Yes.
Lordship, this criminal revision is filed to stay and quash the criminal complaint filed in the Chief Judicial Magistrate Court, Kifire, and by the order dated 23/1/2023, this Honorable Court has stayed the criminal complaint number 1 of 2022. Meanwhile, the opposite party has also filed their objection and we have filed a reply. But at the same time, we are told by our client that amicable settlement is going on outside the court.
Okay.
So
what is this matter about then?
This relating to monetary issue.
Monetary.
Yes, yes.
Okay, but criminal case.
1 of 2022.
So this is criminal case registered against the petitioner.
Yes, yes.
So what is the allegation or the offense? Means the section in both, yeah?
Regarding about the breach of contract.
Or breach of contract?
Yes, no.
Okay, so what do you want now?
So some time may be given for the clients to go for this amicable settlement.
Okay.
Maybe 4 weeks time may be given.
You are for the petitioner. Petitioner. Miss
Kate
Sukru.
Yes.
Okay. For the Lana Council for the revision petitioner submits that the parties are making an endeavor to settle the matter amicably outside the court and pray for some time. Prays for 4 weeks time.
Okay.
4 weeks. Okay, stop. Huh? Now, who appears for the respondent?
Mr. RL is on, but he's not here.
Okay. No one appears on behalf of the respondent. Stop. In view of the above, list the matter after 4 weeks.
Interim may be continued, Lordship.
Stop. In the meantime, interim order passed earlier shall continue. Okay.
Much obliged.
For admission, item number 8.
I proceed, your,
Yes, please.
may it please your lordship.
Yes, please.
My lord, these petitions involving jurisprudence of personal liberty of the petitioner as recognized under Article 21 of the Constitution of India. My lord, these matters, petitions, relate to very tiny facts with a tiny legal issues. My lord, in this case, Police Station 2 Mokokchong arrested 2 persons on 12th June 2023 for possessing 1,440 tablets of spasmoproxybol. Now, these 2 persons were taken to the police station, they were interrogated, and they made a disclosure statements before the police officers in the police stations. And from the disclosure statements, the present petitioner was figured in the case. And so the police officers.
Present petitioner was?
Petitioner figured in the case. It seems they revealed his name as the seller.
Okay.
So the police officers from Mokchong, they went to Akulta. Akulta is on Jammu district. It is just bordering Mokchong. So they went to Akulta town and they arrested the present petitioner. He was arrested on 14 June 2023 and charged him under Section 21C of the NTPS Act, which he purported to be sold by him of that 1,440 spasmoproxybol. A case was registered bearing GR 6623, bearing FR number 29 of 2023, and he was charged under Section 21C of the NTPS Act. My lord.
21C.
Yeah, 21C. My lord. 21C.
Commercial quantity.
21C. Yeah.
Okay.
21C. And this carries a punishment of not less than 10 years, which may extend to 20 years,
yes,
and with fine also. So, since it is a punishment with not less than 10 years, the petitioner did not file any petitions in the court because there was no official report. And after completion of 90 days, the petitioner filed a default petitions in the court under Section 167.
Default bail.
Yeah, after the mandatory period was over. On 14th September, it was filed. It was taken up on 19th September 2023. During the bail hearing, the learned special judge made an observation that since the section involved is 121C of the NDPS Act, which is 10 years, which is not less than 10 years. So she said that it is 180 days and not 90 days. Your Honor, I'm not disputing the power of the special court in extending the period of 90 days to 180 days. Because the location of power is key. The power is, but the location of power and the exercise of that power is 2 different things. Now, special court has to first see that whether investigation officers through the public prosecutor has filed a petition for extension of time before the expiry of 90 days. This was not done. And when I filed petition for the accused on 14 August, it was fixed on 19, and during the hearing, you observe that under Section 21C, the period for detention is 180 days as per Section 36A of the NDPS Act. Section 36A of the NDPS Act says that if Section 19, 24, and 27A, and if it is a commercial property, or commercial quantity, then period for extension would be 180 days, and which can be extended up to 1 year. Your Honor, my Lord, these petitions, it is only confined to whether the special judge is competent without any application from the investigation machinery through the public prosecutor, and public prosecutor giving reason why it should be 190 days in spite of 90 days. Yeah, 90 days as per the CRPC and 180 days as per the NDPSA. So without any formality, without any procedure, without any application from the investigation machinery or by the state council, the learned special judge overlooked the facts, overlooked the legal provisions, and she extended the period of detention from 80 days to 190 days.
Your bail rejected.
And bail was rejected.
Okay.
The full bail. Now I have come here because there's no other ways. There's no other means. Only to invoke the inherent powers of this court. Because, my lord.
Have you annexed reject bail?
Yeah.
Order?
It is annexed at page 28, 24 to 26 in Annex D. Paragraph 4 to 8, 5 to 8. Paragraph 5 to 8 is the bail proceedings, my petitions and the bail proceedings.
Page 24.
Yes, page 24, starting from page 24. Paragraph 5 to 8. That is my bail petition and the observations of the learned special court.
One PP only submits that for the state objected and the bail by stating that the section level against the accused person is 21C and as per the 36A. Investigation and evidence matter to be completed within 180 days instead of 90 days as against section 167(2) of CRPC. Just a minute, whether the application need to be made, Leonard, PP, whether for extension of, because under 167 is the statutory period in this case would be 60 days or 90 days.
90 days. No, Lordship, it is 180 days.
It is 180 days.
180 days, but
automatically, without making any application.
It's very clear in the NDPS Act. But before going to the merit of the case, Lordship, the petition itself is defective.
Okay, just a minute. Let us just see 36A.
36A 4.
36A4, just a minute.
Yes.
NDPS Act. 36. A4.
Yes.
In respect of, kindly read, Land Council, kindly read. Let us read 36A.
Yes.
Do
36A
you have?
clause 4 says,
Yes, please.
in respect of person accused of an offense punishable under section 19 or section 24, section 27A, or offenses involving commercial quantity, reference in subsection 2 of section 167 of the Code of Criminal Procedure 1973 thereof to 90 days, where the court shall be construed as reference to 180 days. Is
See?
very clear?
See, it is clear.
Yeah, so here, my lord, my submission is this. Before switching off from 167.
No, Lordship, let them.
No,
construct.
let me
just,
finish.
you have just read it. Can you read it again? Read it again. Let us read it again. Please, careful.
Procedure. Thereafter 90 days, where the court shall be construed as reference to 180 days.
Yes.
Yes, it is very clear.
Yes.
My lord, it is very clear. But the natural justice requires that when petition is filed, but in this case, petition was not filed by the investigation machinery or by the PP. And if they file also, it has to come. It is not automatic. There are Supreme Court decisions which I have referred in my petitions.
Where it says that it is not automatic?
In my petition, I have referred. I have referred.
No. Here it.
Lordship, let my letter flat read the proviso.
My lord,
Before that, let me
Yes, read the proviso below.
Yes.
Proviso. Read the proviso. Just below.
Yeah, provided that if it is not possible to complete the investigation within the set period of 180 days, the special court, again, another 6 months, that makes 1 year. Now, there is a procedure here, and has been illustrated, this has been explained by the Supreme Court in various cases. Recently, in May 2023, Supreme Court also has made a clarification on this, that since indefensible rights of the accused after completion of mandatory period is being taken away by the court.
That in respect of IPC.
Yeah. It is provided here. Since it is being taken away and it is extended, it's going to be extended to 180 days. Supreme Court says that it has to be, the accused should be given the right to oppose such application. But here in this
where it says?
No, it is given there in verse from Hitendra Vishnu.
Hey, can you just show where it is given? Because this is substantive law.
There is a judgment of the Supreme Court, my lord, on this issue.
You have? Do you have?
Yes, I have. And I have referred.
Can you produce?
I have referred even in my petition. Paragraph 30. Paragraph 11.
Paragraph?
11 of my petitions. My lord.
Page 8. Please.
Yes. Paragraph 11 of my petitions. That the mandatory period of 90 days under section 167(2) of the services can only be extended under section 36(f)(4) of the Act. Mandated on the satisfaction of the twin tests on reports submitted by the public prosecutor with specific reason, presence of accused, or through video conference to oppose the extension of mandatory period of 180 days. And this is not mere procedural irregularity, but the gross illegality that violates the fundamental rights of the accused under Article 21 of the Constitution and deprive the accused of his fundamental right to sex that rebel, resulting in abuse of the process of law and failure of justice. Case selection. Hitendra Vishnu Thakur versus State of Maharashtra, 1994, Supreme Court, page 2623. Sanjay Dutt versus State, Chursi by Mumbai, 1994, 5 Supreme Court cases. 3. Syed Mohammad Kazmi versus State of Government of NCT Delhi, 2012. PL61.
So that means it has to be submitted by the land PP with a specific region.
Yeah.
Okay, let us see the order, whether the PP has submitted. Let us come back to the order, where it was.
The
impugn order.
Impugn order is at page.
Yes. 25.
Page 24 and 26.
25, next paragraph. Kindly just read. Page 25 of your petition, the second paragraph. Let us read the second paragraph. Yes, please.
The effort lodged by UPSC workers stated that.
No, page 25. Second paragraph, the learned council, learned special. Start with the learned special. Page 25, para 2.
The learned special TP for the state object of the bill by stating that the section level against accused person is 21C.
Yes.
And as per section 36A4 of the NDPS Act, request investigation in NDPS method to be completed within 180 days period instead of 90 days. As against section 1672 of CRPC, the investigation are accused person are released on bail.
See, I think that fulfilled.
It will have
He has made a prayer, stated.
Yes.
RPP submitted.
Yes, my lord. But the procedural aspect is that investigation officers, since the case is being investigated by the police investigating officer has to put up a petition to the court, and this has to be scrutinized by the PP, and PP has to give his own reason whether it should be accepted or not. After finding that, the court is duty bound to intimate the accused in custody and inform him that your custody detention for 90 days is going to be extended to 180 days. And he has to be given an opportunity of bail. My lord, this is nothing but the natural justice.
Just a minute. No application, no just such application was submitted by the
Lord,
IO.
I'm sorry to say this, but my learned mislead the court. Read the proviso clearly. The meaning of construe is very clear. In the first 80 says that 90 days has to be construed as 180 days.
Right.
Construed. Very clear, not ambiguity. Then proviso says, if it is not possible to complete the investigation within the said period of 180 days, if it is not possible to complete within a period of 180 days, the special court may extend.
Whether extension order was passed?
Lordship, no. Only after 180 days, and if prosecution wants to retain him for 1 year, the submission, the kind of submission member will come into play. And you allow me to read? May extend the said period up to 1 year. Up to 1 year, Lordship, on the report of public prosecutor.
On the report.
Indicating the progress of the investigation and the specific reasons for the detention of the accused beyond the said period of 180 days.
It is only after, beyond the said period of 180 days.
Yes.
And at the 100, up to 180 days, it is automatic.
Yes, so up to 180 days is clearly automatic. Only
it's not automatic, my lord.
Where is it? The statute, this law says.
See, the state.
This has to be interpreted according to the judgment of the Supreme Court, my lord.
The procedure
the statutory law supports if it is given, then of course. Just see which. Kindly read once again, if you can, for yourself. Because shall be construed. This shall be construed as reference to 180 days.
Yes.
It is clear only.
It is very clear.
Then?
It should be construed as 180.
Yes, then?
But before doing that, the court has to see that whether investigation machinery has made a prayer. Because the Supreme Court is very clear on this issue from various other decisions which I have referred in my applications, in my creations. Very clear that before taking over the indefensible right of the accused who is in prisons, the investigation machinery has to file an application through the public prosecutor. Public prosecutor has to be satisfied that there are reasons that 90 days has to be extended to 180 days. It is not that automatically the court will pass an order that it is 100 days, then indefensible right of the accused will be taken out. It is not that. Supreme Court has made a very clear decision right from 1994 to 2023. My lord.
Now, do you have any ruling where it says that till up to 180 days, no application is required to file by the BP or the I of the case for extension.
The law is very clear. What else?
No, just, I'm asking, because he has produced some,
No,
cited
no,
here
Lordship,
some
he has,
cited-
he cited, but he has not produced the relevant portion. Let him produce first in black and white.
In fact, what I did, I will cite it in my.
No, 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 no. Let him produce.
I can bring it.
Please.
Even now. I can bring it even now.
Please.
But since
But-
it is at this stage.
This is
I
a
have not
serious
brought the
misreading of the court.
citation.
So that is why you have to satisfy. You have to satisfy, and if there is any ruling against statutory law or.
All right,
extend-
all right.
Hmm,
If you permit,
hmm,
after the prayer.
And Lordship, before that, even the petition is very defective, but I'm not taking into all this account.
Okay,
This is coming in criminal petition. It should come under 4339, read with 37 NDPS Act, or if at all, if it's coming under 487, it should come with 482, read with 397 revision. And if my learned counsel submits that is a default bill, he has to file a default bill before session special judge, not here.
It is already
Lordship,
complete. You,
Not
my lord,
complete.
regarding the learners.
We're not trying to go too technical, but if it is to go like this, petition is defective, merit is no merit.
you want some more time? You
Yes,
show
sir.
the court.
To satisfy the court.
Not,
Because since it is for addition only, I have not brought the citation, but it is in order after the
no,
break.
Lordship, give him enough time, not even today, Monday or Tuesday.
Next week,
Yes.
take next week. Bring the ruling if there is any.
It is with me, my lord.
Okay.
But it is only that today I have not brought it. in.
That is why
So-
let him take
so-
enough time.
Hmm.
You
ca-
have to become
I
and
think
say something else.
Need to come prepare properly. And then in that way. Anyway. Okay, hard direct counsel for the petitioner, Mr. NK, assuming. Stop, huh? Also, Mr.
Yeah, come, Lordship.
Planet PP, special PP or PP?
PP, Lordship.
Okay, PP. Nagaland, stop, huh? Is prayed for by the land council for the petitioner. List is matter after next week.
Next
Okay.
week,
Hmm,
by Monday, Tuesday.
Tuesday, Lordship.
Tuesday.
I think it's good for you.
Hmm.
Tuesday, Lordship.
Tuesday, right?
Yes.
On Tuesday is which date?
7, please.
Okay, 17.
7, Lordship.
Oh, 7.
Yes.
So November, yes, 7. Okay. Otherwise, you have received the copy.
Yes.
Okay, okay.
Lordship.
7.
7.
But my lord.
For hearing item number 19.
Okay. Yes. No one appeared. No one appeared for the petitioner. And no one appears for the parties when the matter was called for. List the matter after 3 weeks. Okay.
For hearing item number 20.
May I please, your lordship?
Yes, please.
Your Lordship, this is an appeal, a criminal appeal against the judgment and order of the trial court dated 5th September 2019.
Against the conviction?
Yes, Your Honor. Yes, Your Lordship, against the conviction and sentence. Whereby the appellants were convicted and sentenced to undergo 5 years imprisonment for the offense under section 364 IPC.
364.
Yes, Your Lordship. 5 years imprisonment for offense under 364, that is for kidnapping or abduction in order to murder. And to undergo 7 years imprisonment for the offense under section 304 part 2. That is punishment for culpable homicide not amounting to murder.
Okay.
Both the sentences were passed against the appellants to run concurrently.
Concurrently. Okay. Fine also.
Yes, Your Lordship. No, no
Okay,
fine,
yeah.
Your Lordship. No fine.
No fine.
No fine.
So, Lara PP is present. Okay, so, whether paper book is necessary here?
Yes, Your Lordship. The paper book has already been served.
Served?
Yes.
You received the paper book?
Lordship.
Yes, yes.
Okay. Paper book available? Okay. Okay, ready for hearing?
Lordship.
Okay. Yes, please.
Your Lordship, through this appeal, I'm praying for setting aside the conviction and sentence under section 364. That is for kidnapping or abduction in order to murder. And the reduction on the quantum of sentence passed under section 304. But
You were praying for setting aside of which one?
conviction under
Let us
section-
see the prayer first. Prayer. Set aside 364.
Yes, Your Lordship.
Okay, just a minute, huh?
And the reduction on the quantum of sentence, which was passed against the appellants under section 304 part 2.
And reduction of sentence
Yes, Your
in
Lordship.
304.
Yes, Your Lordship.
Okay. Yes.
Lordship, Lordship, the gist of the case is that the alleged offenses were committed in the year 2013. 4 accused persons were involved, and I'm representing 3 of them.
How many of them are filed?
3 of them.
All of them were convicted and sentences.
Yes, Your Lordship, yes. 4 persons were involved, however, I'm representing only 3 of them.
And you are this petition is for 3.
Yes, Your Lordship.
Okay, what about the other one?
One is absconding, Your Lordship.
Okay, not filed.
No.
Okay, absconding.
Yes.
So he has not been taken to custody also.
No. A warrant has been issued as per the lower court record.
Okay.
However, I'm representing 3 of them.
Okay, let us see the FIR.
Lordship, the FIR is.
Let us see the first allegation. Can you directly go to paper
Yes, Your
book?
Lordship. The FIR is in page 56.
56 of the paper book.
Paper book. Yes, Your
Just a
Lordship.
minute.
Here, the sections were section 364.
FIR 56, yeah. Let us see the allegation.
Your Lordship, as per the FIR, the allegations were under section 364, 356, 392,
Okay,
302,
just
and 334.
let us read the content.
Your Lordship.
Complaint for murder, 58.
58, Your Lordship. I will read it out.
Yes.
With due respect, we submit this letter on behalf of ANTA, Kohima unit, referring to the subject cited above, that a zonal taxi bearing registration number so and so was hijacked, snatched away by two unidentified persons from a garage at Police New Reserve, Kohima, towards Mau Gate at 4 p.m. on 23rd 10, 2013. And it was witnessed that on this 24/10/2013, that the body of Mr. Janul Islam, driver of the taxi, was found to have been bludgeoned to death within the jurisdiction between Biswema and Kusama between 5 a.m. and 6 a.m. Therefore, we appeal your esteemed authority to book the culprits, whoever is involved in the murder of Mr. Janul Islam, and reward benefited punishment at the earliest.
Okay. So the case was registered, investigated, and submitted. Then
Lordship,
the accused was arrested.
yes, Your Lordship.
When they were arrested?
Lordship, they were arrested on on the 24th October 2013.
24/10.
Yes, Your Lordship.
Now, all the accused were arrested on 24.
Yes, Your Lordship, yes.
All three of them.
4 of them.
4.
Yes.
Now you say 1/4 is absconding.
Your Lordship, this is the after conviction.
After
Yes.
conviction, the 4th one
Yes.
absconded.
Yes, Your Lordship. The trial court has convicted the accused persons. Sentence was passed against them, and
So that means during the trial, accused
Lordship.
person were outside the jail.
Not during the trial. After the conviction, we have applied for suspension of the sentence before this honorable court.
Now, how long they have been in the jail? How long these accused persons have been?
For about 1.5 years.
1.5 years.
Yes, yes.
But during the trial period, then they were already released.
They were on bail.
Okay, on
Yes,
bail.
yes, Your Lordship.
So in a trial, okay.
So after the conviction, they were in custody for about 2 months.
After conviction also.
Yes.
Okay.
After conviction, they have served for 2 months. However, pending the appeal, pending this present appeal, they have filed for suspension of the sentence, and presently they are on bail. The appellants.
Okay, so on the strength of the order passed by this court.
Yes, Your Lordship.
They were released.
Yes, yes, Your Lordship.
Okay, then what is your case? What is your ground taking?
Yes, Your Lordship.
Let us see the finding first.
Okay, Your Lordship. Yes, Your
Finding against them.
If-
and then
if-
the ground, let us then we'll come to the ground.
Lordship. If Your Lordship may kindly come to page 29 of the paper book, is the court's order, the trial court's order.
Yes.
This is the trial court order, and the
Your order.
relevant,
Yes.
the finding is in page number page 54.
Inside 34,
Yes, pardon me, Your Lordship.
page 54.
Page 54 of the.
Inside
paper.
page 34. Or what?
No,
There is
26, 26.
There is 2 page. 54. Yes. 54.
54, the second paragraph.
Hmm.
I have heard the submissions made by the learned counsels on the quantum of sentence.
This is quantum sentence
Yes,
only.
Your Lordship.
not a quantum sentence. They're
The finding.
finding against the accused person.
Okay, Your Lordship.
What are
It's in
what is
page
the case against the accused persons?
It's
Alex.
page 40, Your Lordship.
Evidence.
Page 40.
Page 40.
Yes, Your Lordship. Page 40 of the trial court's order.
Okay, judgment.
Yes, Your Lordship. Judgment.
Page 40. Okay.
Towards the third paragraph, if I may be allowed to read it out.
Yes, please.
The evidences which are placed before the court is that the accused had kidnapped the victim as is testified by PW11 that on 23rd 10/2013, while the accused Puzoto Ato, Meningo Tase and Tepusuto Sofie was drinking at BOZ area, Kohima, they were joined by Kehosol, who stated that he knew a taxi driver who used to transport liquor. They all agreed, and Kehosol and Tepusuto Sofie went to CRPF camp area and brought the taxi along with the driver. That the vehicle was taken away along with the driver was testified by PW1, R. Kyrie, and also PW2, Menyoville. Your Lordship, I would like to mention that PW1 and PW2 both are the complainants.
Complainant.
Yes.
Just a minute.
These two are the complainants.
There are two informant. Just a minute.
Yes, Your Lordship.
President and the convener.
Yes, yes.
Okay, yes.
Continuing the paragraph, the court stated that the victim was kidnapped along with the driver and was later discovered that the driver had been killed. The statement of the vehicle owner, though there is consistency of his presence when the vehicle was taken away, the fact that the deceased was kidnapped along with the taxi has been testified and proved. So, Your Lordship, as per this paragraph in the trial court judgment, the trial court has relied upon the statement of PW1, PW2, and the vehicle owner. However, Your Lordship, if we look into the testimony of the complainants, the two complainants, I would like to take Your Lordship to page 87.
You mean to say that these testimonies of these PW1 and 2.
Yes, and the vehicle owner.
Vehicle owner and the vehicle owner.
Vehicle owner is
vehicle owner
PW8.
Okay.
The trial court has relied upon the testimony of these three witnesses and has convicted the appellants under section 364. And therefore, I would like to take Your Lordship to the testimony of complainant 1 and 2 of the two informants.
Other than these trees, were there any other witnesses whom the learned trial court has relied for conviction?
For conviction, yes, there are.
There are also some other person also.
Yes.
These three persons are not an eyewitness.
No, they are not.
Okay.
Lordship,
they are only circumstantial.
Right.
evidences.
Yes,
Okay.
yes. Lordship, I would like to take you to the complainant testimony, which is
Okay.
on page 87.
Page 87. Just a minute. '87. Okay.
Okay. I am the complainant of this case. At the relevant time of filing
This is PW1.
Yes, Your Lordship, PW1.
Okay.
At
Yes,
the
please.
at the relevant time of filing this complaint, I was the president of ANTA, that is All Nagaland Taxi Association, Kohima unit, on the strength of which I have lodged this complaint along with my other colleagues. On 23rd 10/2013, our office received an information that one of our bona fide member, namely Jaimul Islam, was kidnapped by some unknown person along with his taxi. On getting the information, the office have taken all the initiative to find the whereabouts of the kidnapper. However, with utter shocking surprise, we have come to know that the victim was already bludgeoned to death, whose dead body was recovered between Visema and Kusama. Since the matter was heinous, which required thorough investigation and drastic action upon the perpetrators of the office of Anta, had lodged complaint before the officer in charge, South Police Station, for necessary action. The dead body of the deceased was brought by the police and later on handed over to the relative of the deceased. Lordship, this is the statement of the complainant, and I would like to read out the cross-examination of the complainant, which is in second paragraph. Regarding the information about the incident, I had received a telephonic call. However, I do not know the identity of the person who had called me. So as per the statement, coming to the last para of the cross-examination, whatever I am stating here today before the court is only hearsay. So, Your Lordship, the testimony of PW1, the complainant have informed the authorities, the police authorities, and have testified before the court that the information was only based on hearsay as far as the abduction is concerned, section 364. A similar deposition was given by PW2, the second informant, which is in the next page. Even here, towards the second paragraph, on 23rd 10, our office received an information that one of our bona fide member was kidnapped along with his taxi by some unknown miscreants. So, Your Lordship, based on the statement of these two witnesses, complainant, the first informant and the second, there is nothing on record to indicate that the appellants have abducted the victim. As far as section 364 is concerned, nobody has seen the victim being kidnapped by the appellants. There is no eyewitnesses to substantiate whatsoever. And Your Lordship, since the trial court has also relied on the testimony of the vehicle owner,
Vehicle owner is PW?
PW8, the deposition is in page 91. My name is J. Prakash Gupta. In page number 91, the statement of the testimony of the vehicle owner.
Yes.
My name is J. Prakash Gupta, and I run a pawn shop at PR Hill, Kohima. I have been staying here in Kohima for the last 25 years.
Yes.
I had one zonal taxi, and on the day of the occurrence, my driver took the vehicle to the garage for repair. I was informed that two unidentified persons came and took away my taxi along with the driver. Here, the vehicle owner has clearly, categorically testified that he was informed. He has not seen the appellants kidnapping, abducting the victim. And coming to the cross-examination, Your Lordship, the third paragraph. It is true that I did not know who took away the vehicle. And towards the fourth paragraph, it is a fact that I was not present at the time of the occurrence of the incident. So, Your Lordship, as per the testimony of these three witnesses, PW1, PW2, and PW8, upon which the trial court has relied, as far as the section under section 364 is concerned, regarding the abduction of the victim by the appellants, there is nothing on record to substantiate that the victim was abducted by the appellants.
Any other person also has stated about the
Yes, Your Lordship.
incident? Hmm. Where do we find that the Lanark Trial Court has based
Yes, Your Lordship.
on the evidence of PW 1, 2, and 8 for conviction against the accused under 364?
Yes, Your Lordship.
Where do we find in the judgment?
Yeah, here, Your Lordship, the same page number 40.
Page
40.
40. Okay, this is the only.
Yes, the same paragraph.
Achha.
Here, page, the third paragraph towards the middle. The 8th line, or the 7th line. That the vehicle was taken away along with the driver was testified by PW1 and PW2. Here, the trial court has held that PW1 and PW2 has testified. Whereas as per the statements, they have not testified as such. They have not. Nowhere in the testimony of these two witnesses.
Testified, and where the trial court has said that he is basing on it, and then he believed in the statement of the.
Yes.
Where he has stated.
Here, the next line after.
Okay, please.
They both stated that the victim was kidnapped along with the driver. Now the trial court is saying that they both stated, whereas they have not stated anything as per the testimony of PW1 and 2. They have not stated at all.
Okay.
In fact, they have stated that the information given by them was based on hearsay. They have not stated anything as such.
They both stated that the victim was kidnapped along with the driver and was later discovered that the driver had been killed. This is 1 and 2.
Yes, the trial court has held this, has made this observation. However, as per the testimony of PW1 and 2, like I have taken your lordship to the previous complaints, to the previous testimonies, there is nothing as such. In fact, they have denied that they have seen the accused persons.
So they have only heard.
Yes. Additionally, the trial court has also relied on the testimony of the vehicle owner, which is PW8. However,
He is also hearsay evidence.
Yes, yes. He has also testified before the court that he has not seen the appellants abducting the victim.
Yes.
And if your lordship may kindly come to page 41.
What is that?
Here, the trial court has also relied on the confessional statement of the co-accused.
Confessional statement of co-accused.
Yes, your lordship.
Co-accused. Accused number?
It's accused number 2. The confessional statement is reflected in page 41 of the judgment.
Okay.
It's in page 41.
Yes.
So I would read it out.
My
friends Puzoto, Menungol, and Tepusito were drinking at BOC booze joint, and I joined them. Earlier in the day, I saw an auto taxi in a garage near CRPF camp, which used to transport IMFL to Dimapur. As such, my friend Tepusuto, Sofia, and me went to the said garage and brought the vehicle at BOC along with the driver. The three of us went inside the booze joint, and my other friend, Ato, questioned the taxi driver and beat him, but the owner of the booze joint objected. Your Lordship, I want to emphasize this portion, but the owner of the booze joint objected. And so I told Puzoto not to beat the driver inside the...
Booze joint is the name of the restaurant?
It's a liquor shop.
Okay.
Yeah, booze joint.
Okay.
The owner of the booze joint chased us out. And since we were to proceed to Jakama village, 5 of us got inside the auto taxi and proceeded towards Jakama. On my way, my friends beat up the driver. Since the 3 of them were drunk, I was driving the auto vehicle. We took the Agri Link Road to Jakama, but before reaching the village, we turned back and crossed Viswema village. Then I stopped the vehicle for peeing. When I was peeing, the taxi driver was pushed down below the road, and so I reprimanded my friends not to do such things, and I picked up the driver from below the road. Then I suggested my friends to call up the owner of the vehicle or the family members of the driver and ask for money, to which my friend Tepusoto Sofie disagreed. Thereafter, my friend Puzoto Ato leaned against the taxi since he was drunk, and the two others, Menungol Tase and Tepusoto Sofie, beat the driver, who became unconscious. And then the 2 of them, Menungol and Tepusoto, took hold of the unconscious body of the deceased and threw it below the road. The 4 of us went to Kozama and met one driver who is a friend and told me that there is a lookout for auto taxi. And so I parked the taxi and left my friends and jumped below the road and fled through the jungle. I went to Kozama and met a friend, and I requested him to arrange a vehicle to hire to drop me at Jakama. Accordingly, one private auto dropped me at Jakama on hire. As soon as I reached home, I told my wife about the incident. Your Lordship,
so this taxi driver is the victim here?
Yes, Your Lordship. The taxi driver...
The disease is the...
Yes, the disease is the...
taxi driver?
Yes.
Okay. So this is the statement of?
The confessional statement of the co-accused.
Co-accused. Confession. A2.
Yes.
Okay. Okay.
And the finding of the trial court is in the next paragraph, the same page.
Where do we find the 164 statement of this co-accused in the paper book?
In the paper book, it's in page 115.
Yes. So
coming to page 41 again, the finding of the trial court.
Yes.
The last paragraph.
Hmm.
From the confessional statement of the co-accused, Kehosol, it is plain to see that the accused persons after commission of the murder went to the place of the accused Puzuto's sister on the date of the incident. After the co-accused, Kehosol left him on hearing the news that there was a lookout for the auto taxi. This is clinging evidence not needing any further corroboration. Towards the next page.
Yes.
Not needing any further corroboration, as the time, date, and the narration of events are all naturally depicted by the confessional statement of the co-accused. And the deposition of PW 10 and 11. Hence, I hold that the charges under section 364 IPC has been proved against all the 4 accused persons. So as per the confessional statement of the co-accused, PW1, PW2, and PW8, the trial court has convicted the appellants under section 364 IPC, that is kidnapping or abduction, in order to murder.
So whether the defense has cross-examined this okay, this is a confessional statement.
Yes, this is the confession.
Whether the
statement.
magistrate was called for.
Pardon
No.
me, Your Lordship.
Magistrate was called for, no,
He was called for, yes.
to testify the confessional statement, whether cross-examination
Yes,
properly done.
Yes, yes.
But
yes, Your
the,
Lordship.
still, then this statement has come up.
Pardon me,
This
Your-
deposition, this statement has come up from,
from
okay.
164 of the
Okay.
co-accused, yes.
okay,
The other two have declined the confessional statement. However, one have made the confession, based on which the trial court has convicted the appellants.
164.
Yes.
What is the ingredient of 164?
Lordship,
Not 164, 364, sorry.
okay, 364. I'll read it out, Your Lordship.
Is there any other
Yes, yes, Your Lordship.
witness? Gotcha, okay. To prove the 364.
No. As far as 364 is concerned, there has been no other witnesses.
Except these 3 witnesses and one
confessional
confessional statement.
Yes,
So now we have to find out the ingredient of the 364,
Lordship. Yes,
whether it is made out or not.
yes, Your Lordship. I would like to. I have mentioned in my petition. Okay,
Okay, yes,
in page number 6
page 6,
of my petition.
okay.
I have reflected section 364.
Just a minute, huh. Page 6 of your petition. And whether your petition is incorporated in the paper book appeal. Okay.
Yes, Your Lordship. Yes.
Yes, page 6.
Page 6,
Okay,
the second paragraph.
yes.
Section 364
Mm.
provides that whoever kidnaps or abducts any person in order that such person may be murdered or may be disposed of to be put in danger of being murdered shall be punished with imprisonment for life or rigorous imprisonment for a term which may extend to 10 years and shall be liable to fine. This is section 364. And for this purpose, I would like to read out section 362. That is abduction. The ingredient for abduction.
Okay. Where do
362 is in page 7.
Okay.
362 provides that whoever by force compels or by any deceitful means induces any person to go from any place is said to abduct that person. So, Your Lordship, as far as section 362, that is abduction, is concerned, abduction per se is not an offense. Abduction per se is not an offense. However, with the object to murder, if the ingredient is satisfied, then 364 can be attracted, as far as abduction is concerned. Because in our case, kidnapping is irrelevant. Kidnapping has only 2 ingredients. One is from India, and the other ingredient is a child. Yes. So as far as our case is concerned, it is abduction. So if we look into the ingredient of section 362, it clearly shows that the prosecution has to prove and satisfy the court that the appellants have compelled the victim to go from a particular place. However, Your Lordship, my submission is that there is no such thing. There were no eyewitnesses to substantiate. Nobody has seen the appellants. kidnapping the victim. Nobody has testified. And it was based only on circumstantial evidence. And coming to the confessional statement of the co-accused, the confession of the co-accused, he has nowhere stated in his statement, in his deposition, that the appellants have kidnapped. He has stated that they brought the victim from the garage to a booze joint. And if we look into the confessional statement, it is clear that the owner of the booze joint was also present. The owner of the booze joint was present, who objected the fight between them. So now, Your Lordship, if the intention of the appellants was to kidnap the victim, to murder him, the question of abducting does not arise at all. If at all they were to murder him, they would have taken the victim to a different place, not the booze joint. And as per the confessional statement, it is very clear that the location was at BOC. And BOC is a very crowded place. It is a very crowded place, and it is a booze joint. Not the victim was not alone. The booze joint owner was present. He was there. He objected to the altercation that took place between the victim and the appellant.
Admittedly, there was an altercation.
Yes, yes. And it is also clear that the booze joint objected, and the booze joint owner chased them out. So the question of abducting the victim in order to murder him does not arise at all. Does not arise at all. And if we look into the judgment of the trial court has categorically mentioned that the objective of murder has not been made out. The trial court has convicted the appellants under section 304 part 2. That is culpable homicide not amounting to murder. So now when the trial court itself has observed and held and convicted the appellants under section 304 part 2, the question of invoking section 364, that is abduction to murder, does not arise at all. The ingredient of murder has not been established in this case.
So 364 is to?
364 is kidnapping or abduction in order to murder.
Okay.
The object is murder. The very objective of 364 is murder. And for this, Your Lordship, I would like to place a reliance on the judgment of the Supreme Court regarding section 364 in State of West Bengal versus Mir Mohammed Omar, SCC 234. Logic in page 3 of my citation.
This is 8 SCC 234.
Yes.
Page 3.
3.
Okay, yes.
Page 3 towards the third paragraph.
Yes.
Section 364 IPC says, whoever abducts any person in order that such person may be murdered or disposed of as to be put in danger of being murdered, he commits the offense punishable under the section. So, the important task of the prosecution was to demonstrate that abduction of Mahesh was for murdering him. Even if the murder did not take place, the offense would be complete if the abduction was completed with the said objective. That is to murder him. Conversely, if there was no such objective when the abduction was perpetrated, but later the abductors murdered the victim, section 364 IPC would not be attracted. Though in such a case, the court may have to consider whether the offense of culpable homicide amounting to murder or not amounting to murder was committed. So in this case, the trial court has convicted the appellants under 304 part 2, that is culpable homicide not amounting to murder. That was, the sentence has been passed against them under that particular section. Now, here the Supreme Court has clearly stated that Section 364 would not be attracted if the object of murder was not present.
Yes.
Yes, so this is as far as 364 is concerned, this is my submission. And Your Lordship, I would like to take Your Lordship to page 49.
Of the,
Of the paper book, Your Lordship.
okay. Yes.
The third paragraph. This is the judgment of the trial court. The third paragraph, towards the middle, the 9th line.
Yes.
Thus, the conclusive proof of murder is not possible in the instant case. There seems to be no motive also. When it was purported that they should ask money from the vehicle owner, the same was turned down by the accused, Tepusuto Sofie, and no one took any steps to extract money or ransom, taking advantage of the situation. There is neither any evidence to show that there are other considerations for the murder. There is no reason shown why the accused should murder the victim. There is no enmity between the parties. There is no business rivalry or any other ground shown for the court to consider it a reason for murder. This is the finding of the trial court. The trial court has clearly and categorically reflected in its judgment, stating that the offense of murder is not made out. In fact, the trial court has held that the conclusive proof of murder is not possible in this case. So the question of 364 does not arise at all to murder him, the object to murder him. And Lordship, therefore, it is my submission that since the appellants were convicted under 364 and 304, part 2, my submission is that the conviction under 364 be set aside, since 364 is not objected at all. The object of murder was not established. And the trial court has held that murder is not possible in this case. And 364 is very distinctive. It is a very distinctive section. It is basically a section to punish the two offenses, that is kidnapping or abduction in order to murder, with the object of murder. So with basing on the trial court finding, that is conviction under 304 part 2, that is culpable homicide not amounting to murder, it is my prayer that 364 be set aside, Your Lordship. And Lordship, I would also like to make my submission with respect to section 304, part 2.
304.
Lordship,
Initially it was registered as
under 302.
302.
Yes.
Later on it came down to 304.
304.
Okay.
So 304 is classified under into two parts, part 1 and part 2.
Yes.
I was convicted under part 2.
Part 2.
Yes.
Not amounting to murder.
Yes.
Okay.
And the sentence was
So sentence? How
yes,
sentence?
7 years.
7 years.
Yes.
Okay.
For 304 part 2.
There is no minimum here. That's why. There is no minimum sentence under 304 part 2.
There is.
There is minimum, no minimum.
Fine.
Hmm?
The punishment.
No, under 304 part 2, there is no minimum sentence,
Uh,
no minimum maximum.
No. There is.
What is the minimum sentence then?
Wait. There's no.
There is no minimum. Yes.
So, Your Lordship, the trial court has convicted the appellants again under 304 part 2.
Whether under 364, is there any minimum sentence?
No.
364.
No.
364 minimum prescribed. Just see that. 364 just.
No. Imprisonment for life or rigorous imprisonment.
Life or?
Life or 10 years, which may extend to 10 years.
Oh, which may extend to 10 years.
Yes.
Means no minimum.
No. Life imprisonment or for a term which may extend to 10 years.
Okay, that is also no, there are also no minimum.
No.
Minimum not prescribed. Okay, so 304 also minimum not prescribed.
Yes.
Okay.
And the trial court has convicted the appellants under section 304 part 2 and has passed a sentence of 7 years. All the appellants. Now, with respect to this section, Lordship, the appellants begs to submit that begs to submit the mitigating factors with respect to 304 part 2. I'm praying for setting aside 364. However, as far as 304 part 2 is concerned, I'm wanting to submit my mitigating factors for 304. The appellants have submitted that they have admitted to their fault. They have admitted their fault with regard to 304.
Okay.
They have admitted their fault and have taken responsibility for their actions and have maturely sought forgiveness from the family members of the victim. And in return, the family members of the victim had voluntarily and benevolently acknowledged the apology. They have acknowledged the apology, and considering the young age of the appellants at the time of the incident, they have the victim and the family members of the victim have settled the dispute between them, and in presence of the apex bodies of the victim as well as the appellants. The apex bodies of the victim is the Muslim Welfare Society, and the apex body of the appellants is the Angkami Public Organization. So with respect to this, they have executed an undertaking, which I have annexed in my petition.
Okay.
Lordship, unfortunately, the annexure, the undertaking is in the original petition.
Not in a
paper
book.
No, it's not been reflected here.
Yeah.
But it's in my original petition.
Yes.
Page 85. The main petition.
85.
85, yes.
Yes. This was in the year 2014.
Yes, Your Lordship. Here,
when the incident took place?
2013.
13. And then the conviction, the final order, they were convicted?
Pardon me, Your Lordship.
The conviction order passed?
Conviction order is in 2019.
19?
Yes.
So this was, okay, this was executed before trial?
Yes, before trial, yes.
Okay.
This was executed before trial. And I would like to read out the...
Yes, whether this was exhibited during trial, whether this...
Yes, it was exhibited.
Exhibited?
Yes,
okay.
It was.
Yes, please.
the office of the Anta Kohima unit in connection with the death of late Joinul Hussein, murdered by the appellants, Mr. ABCD, on 23rd October 2013. The association has come to the conclusion that by hearing the concern and settlement of both the parties, the association has no objection in receiving an amount of rupees 1 lakh only, whereby to be handed to the family of the deceased, Mr. Rafiq Uddin Chaudhry, account number so and so, SBI, in the presence of the Muslim Welfare Society on 5th February 2014. So, Your Lordship, if Your Lordship may come to the last part of the undertaking.
Yes.
Here, it has been reflected that the undertaking was signed by the family members of the victim. That is in the third point, Joinul Ahmed. The third point.
Third point.
Yes, the third serial number.
Joinul
Ahmed. There's a person named Joinul Ahmed who is a family member of the victim.
Okay, last.
Yes,
okay.
last.
Members of the Muslim Welfare
Yes.
Society.
Yes.
So Joinul Ahmed is a family members
Yes.
of
And
the victim.
Yes.
Mother, father, who? Family member means?
He has no parents.
Okay.
Yes. So a family member was made to execute this undertaking. And in presence of the president of the Muslim Welfare Society, that is serial number 1.
And vice president.
Yes, vice president. And above were the witnesses and the other office bearers. So as per this undertaking, they have amicably settled the dispute between the family members of the victim and the appellants. And so this is one of the mitigating factors that I'm wanting to submit.
Okay, this was presented and then brought before the court.
Yes.
At the
Yes.
time of hearing on the quantum of
Yes,
sentence.
yes, it was.
Okay.
Yes. And secondly, Your Lordship, another mitigating factor is that the appellants also begs to submit that the attack of the victim was in pursuance of an altercation between the appellants and the victim, which took place in a booth joint.
Where from you are reading?
Pardon me, Your Lordship.
Where from you are reading? This is the first mitigating factor.
Yes,
that
yes.
was, no?
The
Okay.
compromise is my
Compromise.
first. Yes.
And the second is?
And the second is, I'm wanting to submit that the attack upon the victim was in pursuance of an altercation that took place between the victim and the appellants in the liquor shop.
What is the purpose of taking this driver or the victim by these accused persons?
As per the confessional statement, they have, since the co-accused has confessed before the trial court, stating that they know a driver of the vehicle who transport liquor.
Okay.
Yes. So perhaps that was the main purpose, because eventually he was taken to the booze joint. And the booze joint was present.
Who took?
One of the appellants.
Okay.
Yes.
Okay. Yes.
He was brought to the booze joint from the garage where the vehicle was kept. Since the victim is a driver, one of the appellants went and brought the driver from the garage to the booze joint. And then the altercation took place in the booze joint. And then the owner of the booze joint objected, since they were fighting amongst themselves. So they decided.
Whether these accused persons knew the victim.
Yes, yes.
Prior to the incident.
Yes,
they were
yes,
known person.
No, they were known to each other.
Known to each other.
Yes. They had no personal enmity, no business rivalry. However, the confessional statement of one of the co-accused had stated that since they know a driver, a person who transported liquor, who transferred liquor, they have decided to bring the victim to the booze joint, and eventually he was brought to the booze joint.
Why brought to him?
That has not been reflected here.
Not reflected
Yes.
anywhere.
Yes.
Okay.
However, it is very clear that he was not taken anywhere to be murdered or anything. He was not. He was brought to the booze joint. They were.
And then thereafter?
Thereafter, since they were fighting amongst themselves, the owner of the booze joint objected, and the owner chased them out. So they left.
They left.
Yes, all of them left, and then they proceeded towards a village.
Village by what means? On
Uh,
foot or vehicle?
By the way, through the vehicle.
How many vehicle?
One vehicle.
How many people total? Five.
Five of them, yes, along
Five
with the victim. Yes.
Okay. Who dropped the vehicle?
One of the appellants.
Okay.
Yes. And
Anyone anywhere stated that he was taken, dragged, forcefully made him to sit in the vehicle?
No, that your lordship. So I'm coming to this part.
Okay.
There's nobody who has seen dragging the accused, dragging the victim. In fact, as per the confessional statement, the owner of the booze joint was present. He was present. And I would like to read out if
Please.
It's in page number 92.
92 of?
92 of the paper book.
Yes.
I would like to read it out.
Mm.
My name is Atsu, and I reside in BOC Kohima. I know the accused persons as they used to visit my house. I have forgotten the date, month, or year, but on one occasion the accused persons came to my house drunk, so I did not allow them to come inside to my house that day. That was the first time I saw the accused person came to my house. I have forgotten whether the police came to me in connection with the present case for investigation.
She's not a material witness.
So this is the statement of the booze joint owner.
Oh, this is the booze joint owner.
Yes. So the booze joint owner has witnessed the incident.
He has.
He was present on that fateful day. However, he has not stated anything as to whether the appellants have dragged, have compelled, used force upon the.
I have forgotten the date. Month. So he has stated that he did not allow them to come, enter inside also.
Yes.
It is in the house, he said.
House as in, since normally, regularly here in Nagaland, what happens is booze joint as
Well,
in.
what is the exact meaning of booze joint?
It's a liquor shop where.
Liquor means
Alcohol.
local.
Alcohol.
Local.
Local as well as IMFL.
Okay.
Yes.
So it is in the form of a shop or just.
Not exactly a house actually. Here normally
House.
what happens here is since it's a dry state.
Okay.
Here people sell alcohol in their homes or anything. So here normally also here in this particular case, the owner of the house, who is basically the owner of the booze joint only, where liquor was sold. The victim was brought in that particular place, in that house. But then since the accused persons were fighting, the booze joint has objected.
No, so he did not state anything.
Yes, he did not state anything as to whether the appellant was dragged, taken away, anything. Not appellant, the victim.
So it is only the co-accused who has stated about that.
Yes, yes. The co-accused as well as
A1.
A1.
A1 or no?
A2. Yes.
And who else has stated?
And PW11 has also stated. PW11, the statement of PW11 is in page 95. Page 95. of
Page
the
95.
Paper book, yes.
Who is he? PW11.
Yes, PW11.
This PW.
And PW11, your lordship, is the investigating officer.
11 is IO,
Yes.
but he is not an eyewitness. He only investigated.
Yes, yes, your
Yes, what he wants.
Since the trial court has relied upon the statement of IO, this also.
Okay, which?
Yes.
Particularly which one?
Your, if your lordship is still in page 95.
90?
95, yes. The
Okay.
statement of the IO. Here, the first line towards the last. During the interrogation of the arrested accused persons.
During the interrogation?
The first line towards the right, extreme right.
Yes.
During the interrogation of the arrested accused persons, it came to light that on 23rd October 2013, accused persons, namely Puzoto Ato, Menungol, and Tepusuto, were, while having liquor at BOC area, accused Kehosel joined them and he told his friends that he know one taxi driver who used to transport liquor. Accused Kehosel suggested that he would bring the taxi driver and the taxi, to which the other co-accused person agreed. Accordingly, accused Tepusuto and Kehosel went to CRPF camp area and brought the taxi along with the driver. Thereafter, the accused person took the taxi and the driver towards Jakama side.
Okay, the
So
taxi belongs to the driver.
Yes, the driver, yes.
And the real owner is somebody else.
Yes, yes. And the real owner has also testified, the vehicle owner also testified that he has not seen.
So this taxi driver is normally he used to drive on behalf of the owner.
Yes, yes, yes.
Okay.
Yes.
On salary basis. Okay.
Yes. And the vehicle owner, Prakash Gupta, earlier I have read it out.
Yes.
He has also stated that he gave his information based on hearsay.
Okay.
Yes. So now nobody has seen the abduction that took place.
So in the garage, any other person were present when the
No,
accused
no.
was
There is
the
nothing
victim?
recorded to,
Acha.
yes,
Nobody
substantiate the
stated.
allegation under
Okay.
364.
So I also not.
No.
Acha. Okay. Then.
So, so your lordship, my only prayer is that 364 be set aside, since abduction is irrelevant
Okay.
in this instant case.
364 setting aside, and
Yes.
then regarding 304.
And as far as 304 is concerned,
Hmm.
and as per the undertaking which I have taken your lordship earlier, as per the undertaking, they have settled the matter between them amicably, between the family members of the victim, the Muslim Welfare Society, and the Angkami Public Organization, along with the appellants. They have agreed that they would settle the matter between them. And
Whether the plea of the accused person at the time of recording the, at the time of the statement,
lordship,
at the time of quantum of sentence,
Lordship.
at the time of passing sentence, whether the accused was also examined or on behalf of the accused, the
yes, yes, on behalf of the accused.
the learned counsel has submitted, whether it was recorded.
Yes, it was recorded. It's reflected in the trial court order.
Okay. Okay. So you have something more to submit?
Lordship, yes, your lordship, if,
Okay, at 2.
okay, your lordship, that would be,
No, no, how long it will take?
not much, your lordship.
Not much.
Yes.
We'll complete that. Okay,
Yeah.
we'll complete
Not
that.
much, okay.
Okay. So now, what is the mitigating factor?
So
that
first is the undertaking,
undertaking
the compromise.
that has been recorded
Yes, yes.
in the order sheet or in the
In my
judgment
original petition, it's there, and
Okay.
the trial court has also reflected in the order.
reflected.
Yes.
So Okay.
However, since even in presence of the compromise that was reflected in the trial court's order, a sentence of 7 years was still passed against the appellants. So it is my prayer to before this honorable court to kindly consider a leniency, because as far as the appellants and the accused, the victim is concerned, Your Lordship, the appellants were 25 years, 26 and 32 years respectively.
25, well, A1 is age
25,
25,
26,
A2
26 and
26,
32 years.
32 years. What
Yes.
they used
When-
to do?
when they
A1, what they used to do?
Your Lordship, presently they are serving as drivers,
All.
and two of them are serving as drivers. One is a farmer.
Who is farmer?
A3.
A3 is a
was-
farmer.
yes. And Your Lordship, since the incident took place, 10 years have elapsed, Your Lordship. It was in the year 2013. 10 years have already elapsed. And the appellants today are in their mid-30s or nearing 40s at the most. They are married and they have minor children, Lordship.
Who has minor children?
All of them.
A1 have how many children?
Lordship, as far as the children, the number of children are concerned, that I have not,
Okay.
I don't have the figures.
Okay.
So, and presently they are serving as drivers and one is a farmer and they are the sole bread earners of the family. And they have a significant social obligation to tend to. And Your Lordship, in addition to that, I would also like to submit that since they have already undergone a sentence of 1.5 years, all of them.
Same.
Yes. They have served 1.5 years. It is my prayer, Your Lordship, that Your Lordship be gracious enough to take a sympathetic view and reconsider the quantum of sentence by reducing it to the period already undergone by them. That's my prayer. Or award a reasonable compensation. In addition to the 1 lakh which they have executed earlier.
So you are ready to pay?
Yes, Your
But then you
Lordship.
say that the victim had no family or parents, guardian.
The family members, there is one here as per the undertaking. As far as the parents are concerned, he has no parents, but he has other family members. So they are still, if at all this honorable court is considerate enough to show a leniency, they are further willing to pay a compensation, if at all it's required. And Your Lordship,
Whether the deceased was married?
no, he's not married.
Married,
He
not
was not
okay.
married.
Okay.
And Your Lordship, with respect to the compromise, I would like to place reliance on the judgment of the Supreme Court, where the Supreme Court, in a cantena of cases, have taken into consideration the compromise, even in serious cases. The Supreme Court has, in various cases, held that the factum of compromise between the parties is a relevant circumstance. And for that, I would. I've
Already submitted, which one?
Yes, I've submitted two citations. And in Murali versus State and the other one.
Yes, Murali.
In Murali versus State, in page number 5. Page number 5.
Yes.
Here.
Keratin.
Yes. I have highlighted the relevant portion
Yes.
towards the last part.
Mm.
The major offense for which the appellants have been convicted
Mm.
is no doubt non-compoundable,
Mm.
but the fact of compromise
Mm.
can be taken into account
Mm.
in determining the quantum of sentence.
Mm.
Here, the Supreme Court has reiterated again and again, even in the subsequent paragraphs, that the compromise between the parties can be taken for quantum of sentence.
Mm.
And my prayer is for a reduction on the quantum of sentence under 304.
Okay.
Yes. So the continuation, it would, in our opinion, meet the ends of justice if the sentence of imprisonment awarded to the appellants, the next page, is reduced to the period already undergone. And similar views have been observed by the Supreme Court in the subsequent paragraphs, where the appellants were made to pay compensation and the period already undergone by them. The sentence has been reduced to the period already undergone by them.
Yes.
And Lordship, there's one last point in the third citation.
Third citation.
In Alistair Anthony Pereira versus State of Maharashtra.
Yes.
Here in page 20,
This is also regarding compromise.
yes, compromise and compensation. In page 23. 23, here, the third paragraph.
Yes.
Having regard to the above legal position and the fact that the mother of the victim had no grievance against the appellant therein, and she prayed for compensation. She prayed for some compensation. This court held that a lenient view could be taken in the matter and the sentence of imprisonment could be reduced, and accordingly reduce the sentence to the period already undergone and directed the appellant to pay compensation of 1 lakh to the mother of the victim.
Who is the nearest relative
The nearest relative is here.
of the deceased? No.
The one who has appended his signature.
Because otherwise this compromise should also not have been executed had the real parents or real of the deceased were alive.
Lordship, the page number 85 of the original petition.
Yes.
Yeah, the person named Joinul Ahmed is a family member, the real family member.
Yes.
I don't know, I'm not sure exactly what's the relation, but then he was the representative. And as per the undertaking, there were 2 other witnesses who is from the Muslim Welfare Society.
Yes, yes.
So if at all it's required, it's Lordship. Yes.
Okay. Yes. Anything else?
So, Your Lordship, in view of the legal propositions that I have cited and the prevalent circumstances, my humble prayer is that, Your Lordship, the appellants be set free. That is from the section under section 364. That is kidnapping or abduction in order to murder. Be set aside. And as far as 304 part 2 is concerned, it is my prayer that the period already undergone, that is 1.5 years, they have already served, and therefore it is my humble prayer that the period the sentence be reduced to the period already undergone, or if your honorable court may deem fit for awarding further compensation for the said purpose.
Okay.
And 10 years, Lordship, like I have mentioned earlier, 10 years have elapsed, and the victims are not further wanting to pursue or press forward the matter, and they have settled the matter between them amicably. And therefore, it is my prayer that if at all it's required, compensation may be awarded in favor of the victim. So that's my submission, Lordship.
Yes, that.
Lordship, as far as the state respondent is concerned, Lordship, there is no illegality in passing the judgment and order dated 5 September 2019, Lordship.
Yes.
Lordship, I would like to make a certain point that during the proceeding at a trial court, Lordship, the appellant, they have not made any denial for this homicide under section 304 instead of 302, Lordship, before the trial court, Lordship. That is my one point, Lordship. And secondly, Lordship, they have not made any defense other than 302 during the trial, Lordship. And moreover, the appellant did not come forward nor make any defense witness before the trial, Lordship. And Lordship, my fourth point is that when they have not made a defense before the trial court under 302, Lordship, whether under filing the appeal, whether it will be permissible, Lordship, since they have not raised before the trial court, Lordship, under when the 304 was passed, Lordship. IPC, Lordship. That is my only.
Okay.
Lordship, I would like to rebut what the prosecution has highlighted. The allegations were under 302.
Yes.
That is for murder. However, as
Trial was proceeded under 302 only.
yes,
Charge was framed under 302 only.
yes,
But at the time of passing the judgment, it was
Yes.
reduced.
it was reduced
304.
and the defense
There
has
was no plea as such.
No plea
No.
as such.
Okay, yes, yes.
The defense has plead for 304.
Okay,
And that is exactly why the trial court has passed under 304.
yes,
We have argued on that point.
okay.
We have made our submission and we have requested the trial court and we have given our reasons as to why it should be under 304 and not 302.
Okay,
And that was essentially the reason why the trial court has come to a conclusion that 302 was not made out and 304 was passed.
yes.
So, and even in as far as this appeal is concerned, I'm not seeking for setting aside 304. I'm
Yes,
not.
yes.
All I'm saying is for a reduction on the sentence that was passed, and if at all compensation is required, it may be passed.
Okay.
However, 364, yes, that part I'm praying for setting aside because abduction at all is irrelevant.
That may also not help you much because in any case, this is
Concurrently, yes,
concurrent. The sentence is
Right.
to run concurrently.
Right, Your Lordship. However, I would also like to make a point that four accused persons were involved. Three of them, for three of them, two sections were passed, 364 and 304. However, one of the appellant who is absconding, the conviction is only under 364.
Okay, not under
It's not
304.
304, yes.
Okay.
So my objective is to set aside 364.
So in that case, if 364 goes, the person who is absconding
Yes,
also.
that's why, because as far as abduction is concerned, it's very irrelevant. It
Okay.
has no invocation of 364.
Okay, anyway. Whether the person who has who is absconding, whether he had also undergone that one year.
Yes, yes, he has,
Okay.
yes.
Okay. Okay.
Oblige your Lordship.
Hard what the land council for the appellant. Miss so-and-so, huh? Also hard, Mr. The BP. Judgment result, huh? See you. Okay. Just a minute, just one. Just a minute, just a minute. Huh?
It's a piece kind of than the judge with a judgment is over. Quarterly Jolana. Oh, this is coming again. You border